Welcome to San Joaquin College of Law Today, a show dedicated to issues and events within the law school which are of general interest as well. SJCL Today is produced by San Joaquin College of Law, a nonprofit law school in Clovis, founded in 1969 to provide quality legal education. Over 88% of its graduates have passed the California bar examination. More than a quarter of the practicing lawyers in the Fresno area are San Joaquin College of Law graduates. This edition of our program features our Constitution Day lecture for 2015 titled, Having Destroyed Marriage, What Are the Gays Up to Now? A conversation with Penn State Law Professor Dara Purvis. Professor Jeffrey G. Purvis examines the recent U.S. Supreme Court decision in Obergefell versus Hodges and interviews Professor D. Purvis, a widely publicized scholar on issues of sexuality and the law, regarding what legal difficulties remain in the LGBT community's quest for full equal rights.
Welcome, everyone present here in the MCLE room of San Joaquin College of Law. Welcome, ye vast multitude of listeners to Valley Views on the Law, and welcome to anyone listening in from the densely populated rat warrens of the eastern United States to San Joaquin College of Law's Constitution Day celebration for 2015. The jackbooted thugs of the federal government coerce us into celebrating the Constitution as a condition for receipt of federally insured student loans. But we would celebrate it anyway, because it represents the shining ideal that each sapient being is possessed by virtue of that sapience of fundamental rights with which even a majority of self-governing persons may not interfere, unless there's a really good reason to do so. Speaking of jackbooted thugs, the Institute for Correct Thinking and Education, a citizens group devoted to improving teaching in America, requires that I make the following disclaimer. Quote, Professor Jeffrey G. Purvis makes frequent use of sarcasm and irony. SJCL apologizes in advance to everyone offended by his remarks. Any opinions expressed by Professor Jeffrey G. Purvis are his alone and do not represent the opinions of SJCL, KFCF, the Pacifica Foundation, the State of California, Penn State Law, the State of Pennsylvania, or the United States of America, whose Constitution we celebrate today. Close quotes. The next thing I say, I stole from Professor Richard Cartier, now retired, when he introduced the valedictorian for the class of 2006, and I like to give credit where credit is due, and if it's not funny, it's Rich's fault. I met Professor Dara Purvis on November 11th, 1981 at 11 p.m. as I watched a team of surgeons perform a C-section on my lovely wife, Susan, who incidentally is a graduate of SJCL, now practicing law in the Fresno area. As sometimes happens with outstanding young people I meet, I stayed in touch with Dara as she graduated from Edison High School with a GPA of 4.35, then was salutatorian at the University of Southern California with a GPA of 4.0, obtained a master's in philosophy from the University of Cambridge, and graduated from the #2 law school in the United States, Yale Law School, where she was editor-in-chief of the Yale Law Journal. Of course, the #1 law school in the United States is San Joaquin College of Law. Professor Purvis served as a law clerk for judges at the Ninth Circuit Court of Appeals and the Second Circuit Court of Appeals, was a visiting assistant professor at the University of Illinois College of Law, and a visiting fellow at the University of Kent Research Center for Law, Gender, and Sexuality. She is currently an associate professor at Penn State Law, where she writes about and teaches in the areas of family law, contracts, feminist legal theory, and sexuality and the law. Welcome, Professor Purvis, and thank you for joining us this evening.
My pleasure.
I can see her right in here. I'm going to commence this Valley Views on the Law program with the most popular segment of Valley Views on the Law, the Peabody-nominated Dear Professor segment, in which I read emails that I have fabricated from imaginary persons and then answer them as a way of slyly advancing my political agenda. I should point out that my co-host, Dean Justin B. Atkinson, teaches contract law and thus was not permitted to take part in today's presentation. Dear professors, well, Professor Purvis, you and your gay allies have finally won. You relentlessly promoted your gay agenda and your gay lifestyle, and now the sacred institution of holy matrimony is sullied beyond redemption. As the greatest Supreme Court justice in history, Antonin Scalia, predicted in his dissent in Lawrence versus Texas, the law profession culture led the weak thinkers on the Supreme Court to, quote, largely sign on to the so-called homosexual agenda, closed quotes, which has now, quotes, eliminated the moral opprobrium that has traditionally attached to homosexual conduct, close quotes. Justice Scalia so presciently observed in Lawrence, quote, today's opinion dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions insofar as formal recognition in marriage is concerned, close quotes. And now Justice Scalia's dark vision has come to pass. After the Supreme Court decision in Obergefell versus Hodges, men may now marry men, women may marry women, and as Scalia warned us, polygamy, incest, bestiality, dogs and cats living together are sure to follow. This looming horror is the product of lawyers and others like you, Professor Purvis, who have forgotten this vitally important eternal truth. The moral rules that we derive from God are not subject to repeal or amendment by mankind. Your homosexual alliance may have won the battle, but God's people will not cease defying you until we have won the war. I will take my sign from the majority opinion itself in the Obergefell decision, which acknowledged, quote, finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned, close quotes. I'm tired of being called a bigot by people who are doing Satan's work. I know I'm right because I am obeying God, and even in his apostasy, Justice Kennedy recognized this. We of the one true faith will never accept that homosexuals are entitled to any rights at all. And that's from Mr. Robert Jones of Grenville, South Carolina. You wound me, Mr. Jones, simply because you hate an entire class of people based on your irrational belief in a supernatural being. I would not call you a bigot. Wait, yes I would. You are a bigot. A group of people have characteristics that offend the values you derive from your religious beliefs, and on this basis you wish to deprive them of the rights that you and others possess. The notion that God's law is somehow superior in authority to human laws reflects a fundamental misconception about self-government and the rule of law. The very reason that we can't put to a vote whether your religious beliefs are insane is the same reason that you can't cite your religious beliefs as a justification for harming non-heterosexual people simply because you believe it is ordained by God. The Constitution forbids both of these things. Some, if not many, of the people who enacted the Constitution were themselves bigots, but the document that they gave the force of supreme law removes certain fundamental rights from majoritarian decision-making. And the people who adopted the 14th Amendment, many of them undoubtedly bigots, stated a rule that limits the circumstances in which different people's fundamental rights may be enforced differently. Of course, how can I expect you, Mr. Jones, to understand what a constitutional system under the rule of law means when more than one Supreme Court justice seems not to understand it? Or is it simply that those justices wish their political values to be effectuated regardless of whether the Constitution prohibits it? Justice Scalia seems to argue that if the government can't make homosexuality or homosexual conduct illegal on the grounds that it offends the religious values of the majority, then it will not be possible to make any conduct illegal on that basis. And if we can't cite our religious beliefs as a guide to lawmaking, then there are no values and nothing can be made illegal. It once astonished me that a person sitting on the Supreme Court of the United States could think like this. The legislature chooses what values will have the force of law, and values based on religious beliefs are as legitimate as any other values based on any other moral system. But the legislature may not actually select values forbidden by the Constitution. Thus, if the legislature selects the value that African Americans may not marry white Americans because the legislature has an utmost sincere conviction that God designated African Americans with the mark of Cain to identify them as inferior to whites, the Constitution does not permit that legislature to give their religious value the force of law. And if a hypothetical Supreme Court justice said that as a consequence of the judicial rejection of that legislative value, it would thereafter be legal for adults to have sexual intercourse with 5-year-old children, that justice would have to be either evil, stupid, or insane. Laws prohibiting sexual intercourse between adults and children are premised on the value that harm to children should be avoided, and people who violate such laws are behaving wrongfully because their specific actions harm children. As the federal courts have repeatedly held after lengthy, thoughtful, and careful examination, no objectively identifiable harm occurs when two adults of the same gender have a sexual or marital relationship. Therefore, no justification, let alone a compelling one, permits the government to deny their fundamental right to do so. Well, welcome again, Professor Dara Purvis, and thank you for being here. The title for today's celebration is and was, Having Destroyed Marriage, What Are the Gays Up to Now? And then there was some more stuff. And I typically try to make the title of the event provocative so that people will take notice of it and attend, as all of you did. So I was wondering whether my sarcasm had any impact on you way over there in State College, Pennsylvania.
Well, yes, it did. I received a concerned email from a gentleman in the Central Valley who is active with a LGBT equality group who I think was puzzled because before he emailed me, I believe he had Googled me and found that I teach the law and sexuality. I'm a scholar of gender and sexual orientation in the law, and I've written about how to achieve LGBT equality. So by the time he emailed me, I think he was puzzled rather than disturbed or enraged, but was he had read the title of the talk and believed that initially that it would be taken at face value. To which I responded, my father is fond of sarcasm, but also that I was kind of profoundly depressed. But I guess unsurprised, I did grow up in the area that someone could read the title and believe that it was to be taken seriously.
If he had been a student of mine, he would have known, of course. Turning to the more substantive issues that we are here to discuss, and I'm going to ask a series of long questions because that's what law professors do. In Romer versus Evidence, Justice Kennedy wrote that the Colorado constitutional amendment treating homosexuals differently and adversely failed even low-level rational basis scrutiny because it represented animus against an identified class of people. In Lawrence versus Texas, he wrote that a law criminalizing homosexual acts was unconstitutional because, quote, the Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. And in Windsor versus U.S., Kennedy wrote that the Federal Defense of Marriage Act violated equal protection and due process because it reflected, quote, a bare congressional desire to harm a politically unpopular group. So it seems like Justice Kennedy, on behalf of the majority, for whatever reason, applied rational basis scrutiny and found it failed, and thus did not feel the need to identify whether or not any higher basis of scrutiny was necessary. I was wondering what purported justifications have been offered as the so-called legitimate interest that would justify denying marriage rights to homosexual couples, and did that change as the court moved towards Obergefell?
Yes, absolutely. It's changed significantly. So initially, in the very first wave of lawsuits asking for the right of same-sex couples to marry, and at this point I'm going back to the 1970s, the very first few lawsuits, these claims didn't even sort of muster any constitutional analysis. They got a sort of back-of-the-hand rejection that the right to marry means the right of a man and woman to marry, and to say otherwise is just ridiculous. There was a couple in prison in Indiana who were fined about $3,000 for bringing such a lawsuit because the judge said their claim is wacky and sanctionably so. So we started out with looking at a dictionary, this is ridiculous. Once we got into the 1990s and the 2000s and began to see sort of a second wave of these lawsuits, there was a whole variety of reasons that were offered to justify limiting marriage to one man and one woman. There were arguments that the purpose of marriage is for procreation. Because same-sex couples do not procreate without outside involvement, they have no reason to enter into marriage. There were arguments that a marriage between a man and a woman is the optimal setting for child rearing, often explained with the importance of dual-gendered parenting. So we need a father and a mother to each model appropriate gender roles and model appropriate heterosexual behavior for the children. There were sometimes arguments that the state is simply conserving scarce resources, that the benefits of marriage are not needed by gay couples, and we should reserve them for heterosexual couples. But the most common, and I think in some ways the strongest argument for quite a long time was, this is very explicitly a moral judgment. We want to limit the institution of marriage to heterosexual couples as an expression of our society's judgment that heterosexuality is morally superior to homosexuality. That disappeared. Most of those arguments disappeared by the time that we got up in front of the Supreme Court in Obergefell this summer and earlier in the spring with the arguments. Really the only argument being presented to the court that they spent a lot of time on was what I like to call the irresponsible heterosexuals argument, which is marriage is not a reward. Marriage is not the carrot in this equation. Marriage is the stick. Marriage is the regulation that we need because heterosexuals keep popping out kids accidentally. So homosexuals, you don't get pregnant accidentally. We trust that you can order your affairs, that you'll be responsible about having children, and we're not really worried about your kids because you've planned for them. You pesky, irresponsible heterosexuals, on the other hand, can't control yourselves, keep having children accidentally. So we need to tell heterosexuals, don't have sex outside of marriage. You should be married before you engage in sex, and that way, if you accidentally have children, those children will have the benefits of marriage and all the rights and obligations and links to the parents that come along with it.
I find that extremely persuasive, but at least since Romer versus Evans, the federal courts pretty universally rejected those as available legitimate interest to justify the government's actions. But as I read, for example, Lawrence versus Texas, where Justice Kennedy spent a great deal of time writing about what appeared to be the assertion that the right to choose one's intimate partners is implicit in the concept of bordered liberty, and that our history does not reflect a thoroughgoing rejection of that, especially in the last 30 or 40 or so years, which sounds to me like a substantive due process analysis for identification of an implied fundamental right. So in Obergefell, did Kennedy persist in talking fundamental rights and then fall back on rational basis, or did he finally identify the rights of homosexual people to have intimate and marital relations as a fundamental constitutional right?
I think he did something in the middle. So he did something more than Lawrence. So Lawrence has all this rhetoric about fundamental rights. It even has a good amount of rhetoric that sounds like he's talking about equality. But then at the end, he says Texas has put forward no legitimate reason to criminalize same-sex sexual behavior. Now, in Obergefell, he does actually say the right to marry is a fundamental right inherent in the liberty of the person, and under the Due Process and Equal Protection Clauses of the 14th Amendment, couples of the same sex may not be deprived of that right and that liberty. So I think he does actually say the right to marry does include same-sex couples. There's nothing gendered in that fundamental right. I don't think he says anything clearly about the intimacy point or the relationships generally point, which may seem semantic and may seem obvious in the sense that if you can get married to someone, surely that's protecting your relationship with that person. But there's been so much variety in how lower courts read Lawrence and applied Lawrence and how narrowly they limited Lawrence's holding to its facts, that I think that even though Kennedy goes further here and says the fundamental right to marry does include same-sex couples, I don't think that this can be pushed much further into other contexts and other issues in the lives of gay and lesbian Americans.
Speaking of substantive due process and equal protection, in my common law class, I tell students that they can distinguish between those two topics with an example like this. A law that makes it unlawful for anyone to marry creates a substantive due process issue. Is there a fundamental right to marry? A law that says only people over age 50 can marry creates an equal protection issue because it classifies the relevant population into two groups. One group that's permitted to marry. I hope you guys are taking notes on this. And another group that's not permitted to marry. And so I tell my students it's actually very straightforward to determine whether you have a substantive due process or an equal protection problem. Yet the majority and the scholarly comment that I've been reading about Obergefell suggests that the court somehow mystically weaves these together and that they have some kind of an interaction that's inexplicable but applicable. Do you regard the court as having difficulty separating them, and what's your take on that particular issue?
Sure. So Kennedy does kind of say these concepts are linked. He says at one point the right of same-sex couples to marry, that is part of liberty promised by the 14th Amendment, is derived too from that amendment's guarantee of the equal protection of the laws. These clauses are connected in a profound way, though they set forth independent principles. I don't think Kennedy wants to talk about the Equal Protection Clause. I don't think Kennedy wants to talk about equality claims of LGBT people, because if he did, it would be much easier to expand the impact of this case and the impact of his holding. Because if you start talking about the equal protection rights of gays and lesbians, that's easier to apply in other arenas. So I think what Kennedy is trying to do, my most sympathetic reading of this, is to kind of compare it to Griswold and Eisenstadt. So Griswold v. Connecticut, the Supreme Court holds that the fundamental right to privacy means that Connecticut's statute banning contraceptives violates the privacy of married couples. Eisenstadt...
But the ban on contraceptives was universal.
Yes.
In other words, in that state, it was unlawful for anyone to use contraceptives.
Yes. So then Eisenstadt, Massachusetts had set up a somewhat complicated system that basically made it easier for married couples to get contraceptives than unmarried couples. They had some lines they drew between what prevented pregnancy and what prevented disease, but the basic line was marriage. And the court said, whatever the right to privacy is, which we don't need to really explain much of what else we mean. But whatever it is, there's no reason that unmarried people have a smaller right to privacy or less of a right to privacy than married couples do. So Massachusetts, this line that you've drawn doesn't make any sense. It's irrational. You have to sort of let married and unmarried people access contraceptives in the same way. I think Kennedy's trying to do that. He doesn't spell it out. He doesn't sort of fully explain it, but he seems to be saying the right to marry, whatever the fundamental right to marry is not just limited to heterosexual couples. There's no longer anything gendered in our conception of marriage. The fundamental right to marry is the right to marry the person that you love, regardless of that person's gender. But I think he doesn't want to say the word equality. He doesn't want to say blah, 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 comma, equal protection clause for fear that that's broader, I think, than he wants to go.
And so conceivably, the lower courts would take equal protection somewhat seriously and strike down other differences in the law between heterosexuals and homosexuals.
Yeah, exactly. So you saw a variety in treatment of Lawrence in the years, especially immediately afterwards. So on the one hand, the 11th Circuit, in a famous case that was challenging Florida, had a law that said homosexuals cannot adopt children. And so the lawsuit had already begun by the time that Lawrence was issued by the court. So the plaintiffs, hoping to adopt these children that they had had as foster children for years, said, the Supreme Court just said, you can no longer punish us for being gay. And the 11th Circuit said, no. All the Supreme Court said is that we can't throw you in jail, and no one's throwing you in jail. And anyway, Kennedy said that Lawrence v. Texas didn't involve minors, and adoption involves minors. Versus the Ninth Circuit, after Lawrence, read Lawrence and said, we don't know why Kennedy's doing all this talk about equality and all this talk about fundamental rights. We think he's created a sort of a new quasi-heightened level of scrutiny that we will now begin applying to the military when they try to discharge gay soldiers. So courts have a huge amount of flexibility, and I think that there's the second you say anything explicit about equality, you give much more coal to the fires of the Ninth Circuit trying to do crazy things like impose equal rights for everyone.
I think a question that my con law students really would demand that I ask you: do you agree with me that the Supreme Court justices are evil, insane clowns? Okay, maybe you shouldn't answer that. The Obama administration and Congress enacted a law that requires employers to provide coverage for contraception for women employees through health insurance, part of the Affordable Care Act. And we, as you indicated earlier, women have a fundamental constitutional right to use contraceptives. Then the government granted those who had religious objections to contraception an exemption from that requirement. What would be the constitutionality in your opinion, of a federal statute that provided a similar religious accommodation of some sort, permitting citizens and others to not honor the equal rights of homosexuals?
So I think that it would be unconstitutional, potentially either under sort of fundamental rights jurisprudence or equal protection. If we're thinking of the right to marry as purely a fundamental right, significant restrictions upon that right would trigger strict scrutiny. So if we are purely talking about fundamental rights and the fundamental right to marry, if there was some kind of statute saying county clerks, let's say theoretically in Rowan County, Kentucky, who don't want to issue marriage licenses to same-sex couples don't have to, if they believe it's against their religion. I think that would be a significant restriction. I think that it would make it potentially much more difficult, depending on your area of the country, to go and get your marriage license and then to become married. However, I can imagine a world and a case and an opinion in which a court could say, no, it's not. You can go to the next county. You can, do the following things that you can eventually get married anyway. And now we don't have to sort of trample on the rights of hypothetical clerks who don't want to grant these licenses. I think it would be obvious, however, that the practical effect of telling one group of people that you may not get your marriage license today if the person you encounter believes that you are sinning by hoping to marry someone of the same gender, the obvious effect is the kind of stigma and the kind of demeaning sort of communication that Kennedy and some of the other justices have expressed concerns for. So if it was me sitting on the court, I would say this is an equality problem. This is clearly sort of enforcing a stigma upon people and treating them differently. But that's why I think, frankly, the whole opinion would have been sort of cleaner and clearer if it were an equal protection clause.
And unlike myself, you might eventually sit on that court. My focus, however, I guess was on more of an establishment clause analysis, that the government is granting a religious accommodation to citizens rather than county clerks who do not wish to obey federal law, and justifying it as, I think they literally may justify it under REFRA, which is a federal statute that protects religious liberty. So, would it be any different analytically for them to say women have a fundamental right to contraceptives and the law says employers have to provide that for them through health insurance, but not you religious believers versus you wedding planners, you bakers, you whoever out there subject to civil rights laws or ordinances that say you must treat everyone equally, but you don't want to cater gay weddings? Isn't that a very direct parallel that would receive the same treatment from the court that the Affordable Care Act exemptions for contraception did?
So the exemptions, you're asking about exemptions for sort of bakers or?
For private citizens who would otherwise be subject to statutes requiring them to treat homosexual people, customers, equally as heterosexual.
Well, so I've read a number of comparisons, either saying how would people be reacting if we were being concerned about the religious beliefs of people who aren't Christians. So say it's the grocery store checkout clerk says, I won't sell you this bacon because I'm Muslim, versus my favorite analogy is because I myself am vegan, would be if I if I worked at a grocery store and said, I'm sorry, I'm not selling you any dairy products or eggs or meat, etc., because I am vegan. The religious motivated exception, in my opinion, is potentially an establishment clause problem because it's granting sort of special concern to a type of motivation. But it's one that there have been a number of debates about sort of state-level religious accommodations, saying we want to carve out exceptions for people from these statewide, municipal, et cetera, non-discrimination ordinances, that somehow it's different, it's more acceptable, and we will credit these religious beliefs above every other kind of disagreement, a political disagreement, an ideological disagreement.
Obergefell and Windsor were both 5-4 decisions. Lawrence and Romer were 6-3 decisions with Justices Stevens and O'Connor in the majority or concurring, and they're both off the court. Do you think it is possible or likely that if Justice Ginsburg were replaced by a Republican president, that the Supreme Court would reverse itself, or even more likely, gradually walk away from homosexual rights, such as the Berger and Rehnquist Court walked away from equal rights for people of color and possibly the Supreme Court walked away from Roe versus Wade over the following 2 decades for contraceptive and abortion rights for women?
Yes, I think you replace Ginsburg with a conservative, and they will be more than happy to immediately overturn Obergefell. The sort of stridency and the strength of the disagreements and the dissents in the case are really startling to an extent. The 4 dissenting justices are angry, and their dissents reflect that. They all accuse the majority of becoming a super legislature. They all accuse the majority of sort of trampling on the political rights of Americans for daring to issue a Supreme Court opinion. We've got Chief Justice Roberts says, oh, just who do we think we are? Scalia says it's a naked judicial claim to legislative power. Alito is saying, you know, this is going to lead to people being called bigots and the nation will experience bitter and lasting wounds. I think there is absolutely no question that if you swapped out Ginsburg or any member of the majority with a conservative justice, they will overturn Obergefell in a heartbeat. My favorite symbol of the anger of the dissenters is typically the justices in dissent finish their opinion by saying, I respectfully dissent. When they're really angry, they'll just write, I dissent, with no respectfully. That's the equivalent of slapping someone in the face with a glove, I guess. Scalia's opinion just ends. He doesn't say, I respectfully dissent. He doesn't even say, I dissent. He flips the table, takes his toys, and goes home.
As I suggested in my absolutely wonderful Dear Professor segment, I think that Justice Kennedy, writing for the majority in Obergefell, invited or encouraged continued opposition to the rights of homosexuals by including the passage I quoted then, and I'll include it again. Finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned. Can you think of any Supreme Court opinion that contains language like that, encouraging people to continue to disagree with the opinion?
Nope.
Can you, what would be your reaction if that passage had appeared in Brown versus Board of Education? And the court said, those who mostly sincerely believe that African Americans are inferior by God's law can continue to advocate for segregation and discrimination and lynchings. It strikes me as incredible and bizarre, and yet, as I repeatedly tell my students, I'm something of a pipsqueak in constitutional law, so I naturally ask you as a scholar, what do you think about that?
I am inclined to agree with you. Here's the most positive explanation of it that I've found from a friend of mine who clerked for Kennedy, although not this term. He read that section as attempting to sort of quell the hysteria of the dissenters. So when Scalia and Alito are saying Christians are going to be persecuted in the streets, this is the end of civilization, cats and dogs living together, mass hysteria, that's Kennedy's attempt to say, it's okay, guys, you can still disagree. That's the best reading of it that I've seen, but I still am not convinced. I think Kennedy knows that a lot of his friends are mad at him. I think that there's a particular sort of care taken to credit religiously motivated bias against homosexuals. I mean, I've encountered it with my own friends, talking about comparing someone who's racist because of religion to someone who is homophobic because of religion. And honestly, I think it's just sort of the passage of time. I think that the people who would otherwise say, I'm racist because God is racist and, the mark of Cain or whatever have you, the judge in Loving v. Virginia, who wrote about the almighty God having placed the races on different continents, and that's how we should remain, that's socially unacceptable. It's become so offensive that nobody says, oh, we have to be nice to the religiously motivated racists. I suspect and I hope in 20 years, people would react to the Kim Davises of the world with the same derision that we would react to a religiously motivated racist person. So I think that portion of Kennedy's opinion is perhaps a product of the times. But I agree that it's extraordinary. It seems very odd to have a majority opinion sort of patting everyone on the head and saying, but you can disagree with me, it's okay.
Well, we certainly have eliminated overt racism from our society, and no one really, would talk about that except a Republican presidential candidate. I wondered if you would compare the likelihood that the Supreme Court itself and the lower courts will treat the rights of homosexuals, at least as identified by Obergefell, the way women's reproductive rights were treated after Roe, because we have an initial, very vigorous defense of those rights, and then a gradual fading to the point of Planned Parenthood versus Casey, when if the law can interfere with a woman getting an abortion if it's not an undue obstacle. Do you think that will happen for homosexual rights? And are you
no. So the strength of Obergefell is the narrowness of its holding, which is gays and lesbians can get married to a person of the same sex as themselves. Bisexuals too, but we never mentioned that. So you can get married to a person of the same gender. That's narrow enough and that's specific enough that I think it would be hard to roll that back incrementally in the same way that we saw the right to choose an abortion being rolled back incrementally. However, the downside to the narrowness of Obergefell's holding is it's just marriage. There aren't really any other rights, even potentially family rights, hanging on this. So this is something I encounter with my students a lot. Pennsylvania has allowed same-sex marriage for a little over a year now due to a federal district court decision. And so I would have students coming into family law or coming into law and sexuality and thinking there have been great strides in equal rights for LGBT Pennsylvanians, when the truth is you can be fired in Pennsylvania for being gay. There's no employment protection. There's no federal employment protection. There's no employment protection in most states and most areas. This is a victory, but it's an extremely narrow one. And so I don't know that the holding will be rolled back so much as courts will just say, okay, they can get married, but that doesn't speak to anything else. We don't have to let them do anything else.
How can a judge justify disparate treatment of homosexuals in the fashion you just described, given that they have a fundamental right? And a fundamental right triggers strict scrutiny when the government classifies in a way that adversely affects that right. So is it that they are simply, as you say, limiting the fundamental right to marriage, period? And isn't that insane or evil? What possible justification can there be for that except I'm the judge, so I say what happens?
Yes. So Mississippi.
I don't mean to lure you into legal apostasy. I can be free with my criticism of the justices because I've got nothing to lose, basically. But For my students who I am relentlessly teaching to be analytical, what possible justification is there for a decision of that nature?
Well, so the logic is, okay, so you can get married. Here is your marriage license. That doesn't tell us anything else about any other fundamental rights you might have. That doesn't tell us anything else about any equality-sourced rights that you might have. So Mississippi is one of the last states to explicitly prohibit adoption by same-sex couples. And there's a lawsuit challenging this right now, and the lawsuit is citing Obergefell and saying we have the fundamental right to marry. Shouldn't we have the fundamental right to adopt? Isn't that part of the fundamental right to privacy? Isn't that sort of part of family rights when you're talking about the importance of family and the importance of marriage? And the Mississippi governor and Mississippi state attorney general are saying absolutely not. Fine, we can be forced to let you get married, but adoption is not a right. We have to make a decision about what's in the best interest of the child. And so we can certainly say the jury is still out on the impact of being raised by same-sex parents. And really in any other arena, with the exception of some variety among lower courts who sometimes have tried to apply heightened scrutiny to classifications based on sexual orientation, if all that the state or the government actor has to put forward is a hypothetical, legitimate state interest, and they just have to explain how it's the classification is rationally related to that, that's incredibly flexible. You can come up with things like administrative convenience. We're not sure what the impact will be. We're concerned about conserving resources. We have a lot of other groups that are facing explicit discrimination, and we want to focus on helping them, so we don't want to devote the resources of our attorneys and the courts to this very vocal minority. We think you're doing well enough in the political process and you don't need these protections. There are all sorts of reasons you can come up with to distinguish marriage from other arenas, even within family law, and all sorts of reasons that you can come up with to justify different treatment.
Here at Valley Views on the Law, we pride ourselves on occasionally channeling our inner conservatives and attempting to be actually objective about the topics that we discuss. And as I did that in preparation for today, this comparison occurred to me, and I wanted to see what you thought of it. That clerk in Kentucky who refuses to obey the law because she feels that it is a violation of God's laws, of her religious beliefs, versus a person who believes that God forbids us to kill each other in anger or in war, and so trespasses on a military installation to try to interfere with the passage of nuclear arms or in some way support peace and resist what they regard as a religious evil. Aren't both of those people, in fact, engaging in civil disobedience? And as progressives, we're usually receptive to people engaging in civil disobedience. So should we regard the Kentucky county clerk with the same equanimity or maybe even approval that we regard the nuns who trespass on military installations?
I see the comparison. I'm sure that people who are sympathetic to Kim Davis's point of view see it as civil disobedience. And I'm okay characterizing her actions as civil disobedience, but one of the important aspects of civil disobedience is that someone who is engaged in civil disobedience knows that they're acting against the law, and they are willing to sort of put themselves sort of in harm's way, in a sense, at least in a sort of legal liability kind of way, to express that. So I'm okay with labeling Kim Davis as engaged in civil disobedience, but I think that a consequence of her civil disobedience should be that she loses her job, not that, say, presidential candidates talk about how prosecuting her is some terrible war on Christians. The law is clear. Her duty under the law is clear. She can choose not to do it, but she has to accept the consequences of refusing to do so. And I don't see any reason, I don't think civil disobedience in and of itself is praiseworthy. I think civil disobedience against unjust laws can be praiseworthy, and obviously my sympathies lie elsewhere.
Well, yes, who determines which laws are unjust?
Me. Maybe you. I mean, each of us can in our own, this is an individual judgment that each of us make. And it's fine for people to think that laws are unfair. But what disturbs me is this sense that because the reason she thinks the law is unfair is her religious belief, that somehow that makes her disagreement better than my being really annoyed at the alcohol regulation in Pennsylvania that I can't buy beer at the supermarket.
Okay, I usually like to provide an opportunity for you members of the audience to ask questions of me, since I'm usually the star of these shows, but I thought it might be even more appropriate and enjoyable for you to ask questions of Professor Purvis. So if you have any questions, I'm not sure if she can hear you, but ask them and I'll repeat them and give you an opportunity to talk to a real law professor. Or okay. Well, wait, there is a question. Yes, sir.
So my question actually follows from your last bit of discussion there with Kim Davis and civil disobedience. One thing that my own feeling about that situation is that she may be confusing her acting as an individual versus acting within her individual, as her official capacity as a clerk. And that might distinguish the case that other Dr. Purvis mentioned about the civil disobedience of the nuns on the military, who are not acting as an official capacity, but in their individual capacity. And I wonder if that affects your analysis at all.
Did you hear that?
Yeah, I think so. I could hear just about all of it. Yes and no. So I think it's relevant to the extent that this isn't a private actor protesting something. I presume most of us, because we live in the internet world, have seen sort of the meme that popped up about do your job, with all sorts of different people saying they didn't actually like this thing, but they still did their job. My favorite was a picture of Freddie Mercury that said he didn't actually like fat-bottomed girls, he still did his job. So I think there's a bit of a difference between sort of I disagree with this law and I'm going to engage in specific protests against it versus my job function is this thing. There's a little bit more of a structure in some capacities for employers trying to give workers, religious workers, accommodations for religious beliefs that cause problems at their work, like if they don't want to work on a Saturday or a Sunday because it's the Sabbath. So I think that's a little bit more familiar to us in thinking about what kinds of accommodations sort of might be offered. And in that sense, I think it would be more reasonable, I'm still not particularly sympathetic, but potentially more reasonable to ask for a minor accommodation. And so we saw this a little bit in Kim Davis's case because she started off saying absolutely no marriage licenses being issued to same-sex couples whatsoever, not only just by me, but anyone who works for me. And then this gradually kind of got rolled back into smaller and smaller requests like take my name off the marriage license itself so I don't have to sign it so my name doesn't appear on this kind of thing. That kind of accommodation, when it's requested properly rather than just telling people, no, I won't give you the marriage license that you're entitled to, in a soft sense, I find more sympathetic. But I think the root attitude is still the same and is potentially more problematic since she signed up. She presumably took some kind of commitment or oath to uphold and enforce the law, and she's now decided that her sense of the law is somehow different and better and superior to what the law actually is.
Good answer. Any other questions? Library Director Rest?
So my immediate reaction is to jump to family law because that's what I write about. I write a lot about non-traditional parenting, so that's why adoption and other methods of creating a family leap to mind as particularly important. I am not sure, and the other distinguished Professor Purvis can jump in if you are more creative than I am. I'm not sure that there are other claims that are going to be framed easily as fundamental rights. So the next major issues that I think that the LGBT equality movement will be working towards are things like employment protection. I don't think you can frame that easily as a fundamental right itself. I think you can take language from these opinions to try to apply it. But it starts to look more like an equality claim. I'm not sure how much outside of sort of the creation of the family and potentially some relation of other conduct that's intrinsically part of the relationship can easily be framed as a fundamental right. And that's kind of, in my sense, one of the most negative aspects of Obergefell.
Excuse me. That brings us to the end of this Constitution Day celebration and to this broadcast of Valley Views on the Law. Sorry about that. My particular thanks to Professor Dara Purvis of Penn State Law for taking the time to share her expertise with us. Thank you all for attending and for listening. Dr. Martin Luther King Jr. said, quote, "The arc of the moral universe is long, but it bends toward justice," closed quotes. I have questioned for myself whether humans are moving towards greater justice, but my lifetime has seen significant advances in equal rights for people of color, for women, and now for the LGBT community. There is much more to achieve, but as lawyers and as judges, our best hope for justice is to commit to protecting and defending the Constitution of the United States and to interpreting and applying it in good faith according to neutral principles of law. As citizens, we must support the Constitution and do all that we can to bring to fruition its promise of liberty, equality, and justice for all. Thank you and good evening.
And that brings us to the end of this edition of San Joaquin College of Law Today, presented by San Joaquin College of Law, a nonprofit law school committed to educational excellence and community service. The views expressed do not necessarily reflect the position or views of San Joaquin College of Law. This program has been produced in conjunction with the Community Media Access Collaborative. We invite you to join us in the future as we explore issues and events within the law school which are of general interest as well. For more information about San Joaquin College of Law, please visit our website at www.sjcl.edu or call 559-323-2100.